Welcome, everyone. Today we're having a KCA Safety Committee lunch and learn, and the topic is feeling the heat, how contractors should protect workers from heat hazards in the current climate, the current OSHA climate. So we have two guests today. We have Michael Metz-Topodas and Rocco DiPietro, and they're kind enough to join us and create a presentation on this topic. And should be a good one. Make sure to chime in with questions before or during the slides. And without further ado, I believe Michael is going to kick us off.
Good afternoon, everybody, and welcome to today's discussion. I think Seth nailed it with the intention that we want people to ask a lot of questions about what we have. Really, it's a matter of just putting out some ideas about heat hazards and what OSHA is doing regarding that, and letting folks just chime in with whatever inquiries they may have about this topic that are more pertinent to the work that you're doing on a day-to-day basis. By way of overall introduction, my presentation will focus more on regulations, as you can see from the title on the screen, and sort of where OSHA is on its heat hazard illness and injury prevention or protection rule. And then Rocco is going to talk a great deal about some of the particular aspects of heat hazards and what safety professionals can do to protect against it, regardless of where the rule is. Rocco's information is wholly relevant, as I will explain, because one way or another, OSHA can find a way to enforce some kind of, or take some kind of regulatory action or enforcement action based upon heat hazards. But before we get too far along, let me take a moment just to introduce myself and the work that I do. As some of you know, I am a lawyer. I practice at a firm called Saul Ewing. I'm a partner in the firm's construction practice group. I work out of both the Harrisburg and Philadelphia offices, although Philadelphia is sort of the official address on my bio, and that's why I put that. A lot of people also, when I give presentations, I always give a little bit of background about myself so you understand where I am coming from. And succinctly put, I am a lawyer, and that's the top right-hand corner, the justice symbol there, but also a construction lawyer. My practice focuses entirely in the construction industry. That includes everything from bids, bid protest, contract review and drafting, litigation and claims at the end of a project of all different types, delay, differing site conditions, mechanics liens, bond claims, you name it, I've done it. Federal, state, public, private projects. I've worked for owners, contractors, subcontractors, sometimes even suppliers, sometimes even designers and sureties as well. So I've done it all in my practice, and that also includes as you see in the center there, OSHA compliance and enforcement defense. That is actually my OSHA 10 card. I've sat through the course. It was tremendously helpful in terms of getting to the nuts and bolts that arise on any particular OSHA matter I'm involved with. My OSHA work involves, helping companies and construction contractors to understand how best to comply with existing regulations, and also defending them against citations that may be issued, or handling other aspects of OSHA investigations that may arise, including investigative demands or just requests for documents. By way of background, I went to law school at Temple University, so that's sort of my Philadelphia connection, which even goes back to my undergraduate days, where I attended Swarthmore College, which is outside of Philadelphia. Before becoming a lawyer, I was a teacher for 9 years. That's that top center picture there. And so presentations like this sort of take me back to those days. No one's getting detention today, however, so you're lucky about that. And believe it or not, in college, I was a philosophy major. I'm living proof that you can actually find employment even with a philosophy degree. Or as one person joked to me, I'm not destined to be work at Starbucks the rest of my life. So, but of course, the question people always want to know is like, okay, all that aside, like, who's your favorite football team? Who do you root for, right? And in living in Philadelphia, well, back when I taught, was a teacher, I taught psychology among other topics. And so we talked a lot about subliminal messages. And since I live in Philadelphia, and for my own personal safety, I will just keep that information subliminal and move on from there. As we talk about heat, injury, and illness regulations, OSHA, as some of you may or may not know, has a pending regulation, pending I say, and I'll explain that as we go forward, regarding heat injury and illness prevention. That regulation didn't come from out of nowhere, and it actually has a long history to it. So I want to take a moment to talk about the history of that regulation, talk about what the proposed regulation says, talk about why it's still pending, and then talk about why it still matters, and also what might happen to that regulation, both in terms of whether it could get approved, and even if it does, what could happen to it in hindsight. But this all goes back to, well, for the longest time, all you had from OSHA with respect to heat illness and injury was just a lot of information. Posters like what you see right here, information on its website about safety measures that employers can take to protect their employees, guidelines about the dangers of heat, how to monitor heat, and the hazards and risks that are presented. But that was about it. There really wasn't too much OSHA could do other than use its general duty clause. So as a result, and we'll talk about how that would play out going forward. In addition to such information, in 2022, OSHA implemented, a national emphasis program. Some of you who are safety professionals, understand that that is a prerogative OSHA has, where they place an emphasis on certain types of employment hazards that'll involve, depending on how the emphasis program is created, will give OSHA sort of a variety of, or give OSHA priority to certain initiatives that it can otherwise take, both in terms of education and, as well as in this emphasis program, additional inspections. So it basically said that OSHA could orchestrate a series of programmed inspections. That is to say, they would draw from random certain types of employers whom they thought would be subject to heat injury and illness risks or hazards, and then conduct inspections on a randomized basis of those. But usually, I don't know if anybody knows about the program inspections, OSHA has like a random generator, will generate a list of employers and that they're going to inspect, and they'll go out and do those, subject to some of the more emergent inspections they do, say when an accident occurs or an injury happens. In addition to those, and those program inspections, in addition to the ones that occur through the National Emphasis Program, OSHA was also performing independent program inspections on targeted industries in their area, in particular, for obvious reasons, agriculture. As to then how they could enforce any kind of requirements as how employers should address the heat injury and illness hazards, it really fell under the general duty clause. And that is a provision in the OSHA Act. It's not a regulation. It's not part of the regulations that OSHA itself has created. It's rather in its statute that gives OSHA its authority to operate. And it requires that each employer give its employees a place that is free of recognized hazards that are causing death or serious injuries, or could. So pretty broad and basic language. But OSHA will turn to this when it doesn't have a regulation to enforce. Usually when there's some sort of catastrophic or tragic event, like a fatality or serious injury, because they don't want to be left being unable to respond to something like that. So they'll default to the general duty clause. The problem is the courts don't look at this with great favor. The burden of proof for OSHA is much higher. So it's really not the way it wants to go. It also has a heavy requirement for what OSHA has to prove. They got to prove that a condition in the employment, a condition or activity in the place of employment presented a hazard. Okay, that's pretty basic. That's what you'd have to do with any sort of regulatory enforcement. The employer or the industry recognized the hazard. And that's where OSHA gets into a problem, because they don't have a regulation they can point to that recognizes the hazard. So they have to show that it's something that's recognized by the employer, or known by the employer or the industry. And proving actual knowledge or even constructive knowledge can be difficult. What OSHA will turn to in that situation is a lot of those publications that we talked about earlier. The posters and information it puts out there says, hey, employer, you should have known that heat is a hazard, okay? But that still gives a lot of wiggle room to somebody like me to say, no, we should have known that. How are we supposed to know that, okay? And so that's why the general duty clause is disfavored. The other two elements is they have to prove that the hazard is causing harm or likely to. Pretty easy on heat there. And then feasible and effective means existed to eliminate the hazard. Again, by and large, there is a means, maybe not quite the way OSHA would want it, but certainly there are feasible means. And the reason I'm cautious about saying that is that there currently is a debate about whether these the proposed heat hazard regulation that OSHA would like to implement is feasible for employers, or is it too restrictive and not flexible enough for the variety of different workplaces that it would apply to? But we're getting ahead of ourselves a little bit. And so that's where we were for the longest time until late 2021. There was an advance notice. So basically OSHA said, hey, we're thinking about putting out a proposed rule. They then spent the next 2 years or so most of 22, most of 23, just meeting with their various industry groups, focus groups, et cetera, gaining information about what a rule would look like. And then last year, as some of you remember, they announced that they were going to offer a rule, which is very strange. Usually they just put out a notice of a new rule, but they announced that it's coming, and it didn't come till August, as some of you remember. And then in December, the comment period closed. Now, some of you may or may not remember, but in between July and December, there was actually an election, and we had a new president come in. And so the heat hazard rule sort of found itself in limbo because no one sort of knew what the new administration was going to do with it. And we found out soon enough. But before we do that, before we get ahead of ourselves, just to give you a quick summary of what that rule meant, it had 6 major requirements for employers. They had to develop a heat injury and illness prevention plan. They had to identify and monitor hazards at specified times, regularly checking for heat hazards, every couple hours, checking the temperature, humidity, et cetera. There's actually measures identified in the rule, as some of you may know, about what they had to do. Then they had to implement controls based on certain heat triggers. Rocco will get into more of the details about that. And then also have an emergency plan. So in case somebody did fall ill or suffer from sort of heat stroke or other heat-related injury or illness, a response, they had to have a program in place where employees could respond effectively to that injured or ill worker. And then, of course, additional training was required for employees about heat hazard and injury. And of course, this now was putting teeth into all the information and slogans and posters and whatnot that OSHA had been issued before. However, this rule still remains in limbo. After the comment period, presumably under perhaps a Democratic administration, if Vice President Harris had won the election, presumably they would just proceeded with then approving the regulation. It had already gone through the comment period. But instead, some of you remember the day that President Trump took office, he issued a regulatory freeze. And essentially what that did is it said that any pending rule, like the heat hazard rule, would remain or be withdrawn until reviewed by a president-appointed head. Okay, so that meant that OSHA would need an appointed head to then look at that rule. And to this day, it still does not. David Keeling is up for confirmation with the Senate, but they haven't moved forward on finalizing that. Then, additionally, too, kind of strange, they introduced a public hearing. And so you had to submit an intention to testify. And they had from July 16th to July 2nd, it was on Zoom. Anybody could join and participate and testify had they put in a notice they wanted to do that. And a lot of industry groups did do that. The thrust of that complaint, there were multiple constituents, and they were emphasizing the need for flexibility and also the infeasibility of the rule. They said it was too prescriptive. Okay, some were saying it was too prescriptive, and others, a lot of the more labor-oriented organizations, including unions, were saying, no, it doesn't do enough. We need more breaks, more required protections for people working in the heat. And I said some say it was prescriptive, and others said it was too that it should have been more about performance. And what I mean by that is some said the rule was telling employers you must do A, B, and C. You must check the temperature at this time every few hours, et cetera. And others said, no. The rule should be you will ensure that there are no heat injury and illness related incidents on your workplace. And you can do that however you see fit. because, certainly dealing with the heat in Bangor, Maine is much different, or Fairbanks, Alaska is much different than Tucson, Arizona. And so that by having a performance standard, you get the flexibility that people wanted in the rule. So where do we stand now with the rule? Well, in addition to that hearing, now they've opened it up to briefs and comments. And that period closes in September. At that point, then the rule presumably will be sent to the Office of Management and Budget and the Office of Internal Review and Affairs. That process could take years. We also need the appointment of a new OSHA head unless the Trump administration withdraws that executive order. And some say there might be just grounds for a new notice of proposed rulemaking because the changes to the existing rule are so different from the proposed rule that it is unfair to pass that rule, and we need a new notice period. And as well, too, because of all the challenges to the pending rule, OSHA might just say, forget it, this thing's not going to fly, let's try a new rule anyway. This is our friend, Mr. Keeling, who still awaits confirmation by the Senate. The other challenge and obstacle to the rule is something called Loper-Bright. I won't get into the details, but this is a Supreme Court case that removed a deference to agency discretion about the rules it could make. OSHA is only allowed to make employment rules because of the OSHA Act, which gives it the authority to make those rules and regulations that we see, in the federal code and whatnot, the Federal Register, excuse me. And for the longest time, courts said, well, listen, OSHA, if you think that the rule is within your power to make, then we will defer to your judgment, provided there's no ambiguity in the statute. The statute is clear about what rules you can and cannot make, and we think, court, you've gone outside your power, we'll say something. But if it's kind of ambiguous as to where your power lies, OSHA, then we will defer to your judgment as to what is and is not a rule that you're entitled to make. That was the old standard. Loper-Bright came in as a Supreme Court case, and the Supreme Court said, wait a second. I don't know what this other Chevron case, that was the old case that gave that deference. I don't know what they're thinking. We, the Supreme Court, get to interpret statutes and nobody else. That's our job under the Constitution. And so we will determine, as we are instructed to do by the Administrative Procedures Act, another statute, we will determine whether OSHA has acted within or outside the boundaries of what the OSHA Act allows it to do in terms of the rules it can create. Now, if you think that the heat hazard rule falls within OSHA's power, I want to give you some thoughts about that, okay? That's what Loper-Bright did, reestablished full judicial review. We got that. We talked about that. Well, let's talk about heat for a second. Heat is a hazard of daily life, right? It's around us wherever we go, whether we're working or not. You can be working in your garden or picking produce in a field. Either way, the heat you are experiencing is the same. And so most Americans then therefore face the risk of heat while on the clock just because most Americans have jobs. And so really heat is a broad public health concern. It's not really an occupational hazard. It's not strictly confined to employee safety and health. And so the proposed heat injury and illness prevention rule would expand OSHA's regulatory authority without clear congressional authorization. Because if you look at the OSHA Act, it says, OSHA, you may regulate employment hazards. You can't regulate just hazards that are out there for everybody. That's not your job. And if you think that argument won't fly, I will tell you that I basically cut and paste that argument. I copied it almost verbatim from the Supreme Court's reasoning in the rejection of an emergency temporary standard that OSHA implemented in 2021 that said to employers, you must either require your employees to be vaccinated from COVID-19 or require them to mask and test on a regular basis. And the Supreme Court said, wait a second, that's not an employment risk. That's an everywhere risk. You can't regulate that, OSHA. Your what they call the vaccine mandate, which is a bit of a misnomer, was then stricken as a result. And so my point is that reasoning was accepted with respect to COVID-19, something that was in the air all around us. There's an argument that heat isn't any different. and therefore the same reasoning should apply, especially because we're not going to defer to OSHA thinking, yeah, we got the power to do this, of course. So my point is there's a great opening for the Supreme Court to step in here with that new case. There also could be just a withdrawal of the rule. Like I said, I think we talked about that. OSHA might just say, forget it, we're going to start over. And then finally, even if the rule persists, if you look at the big, beautiful bill, OSHA's budget was cut significantly. And as perhaps you may have noticed, they've been cutting staff all throughout the administrative agencies, all throughout Washington and beyond. So there's a potential that OSHA is either going to have less money to pay its people or less money available, so therefore fewer positions it can pay. And of the positions that do exist, a lot of them are getting cut. So what you end up with is less funding, fewer COSHOs, compliance, occupational safety, and health officers, the people who go out and do the inspections. If you have fewer officers inspecting, you're going to have fewer inspections. If you have fewer inspections, you're going to have fewer citations, and of course, less of an ability for OSHA to cite employers for any heat hazard violations. So that's sort of the conclusion for me. I don't know if I want to take a break for any questions on the regulatory side, or just jump into Rocco's discussion of sort of where I leave off. As I always like to say, like I can tell you about all the rules for fall protection. I can tell you how to make a good fall protection plan. But if you want to ask me as to how a harness should fit, I defer to a guy like Rocco. And I think here that's the same thing that we're doing. I don't know if Bill or John or anybody else has any questions. Otherwise, we can proceed to the second part of this.
I do have one question, and you did touch on it a little bit, and I was also a couple minutes late getting on, so if I missed it, I apologize for that. But you talked about the performance standards, how essentially there's different rules for different parts of the country based on geographical location and whatnot. Kind of what exactly is different as far as like metrics and all that kind of stuff? Like how would OSHA look at a case in Arizona as opposed to Maine, to use the example that you gave?
John, I may have spoken too quickly, but what I was the point right now with the rule is that it's a one-size-fits-all rule. Everybody's got to check for heat hazards at this time, at these regular intervals. Everybody's got to have a plan, etc.
Sure.
What I was arguing and what some of the opponents to the rule are saying is, wait a second, if I'm working in Fairbanks, Alaska, the risk of heat here is much different than in Tucson, Arizona. So we have a rule that allows us to adjust for those different concerns. That said, quite honestly, I mean, if you really start thinking about it, is it a heat injury illness or is it a weather injury illness, right? Because winters in Fairbanks are way different than Tucson too. And so maybe we need a rule that accounts for that and allows employers to have that adjustment. And as well too, it's also going to vary according to workers. To use those two cities. Someone who's lived for 10 years in Fairbanks and all of a sudden has to find themselves working in Tucson is going to need a period, as Rocco will get into the science and the details of it, it's going to need a period to acclimatize. And so therefore, again, the things that protect those workers in Tucson who are used to the heat for years upon years are going to would leave somebody from Fairbanks very, very vulnerable to all kinds of heat injuries and illness. So I think that was the point with all that. But I think you're right that OSHA is going to look to each particular circumstance, and given individual circumstances, I think there is an obligation to a degree for an employer to keep that employee safe, and it's going to be fact specific. But yes, if you had a worker that was new to the area, yes, you need to be keenly sensitive to that, especially if you got information about that. And so how OSHA would look at it, John, like with so many of these cases, having done so many, they can be really fact specific. And I think the detail in Rocco's presentation will illuminate that as well. But it's a great question.
Awesome. Thank you.
No problem. Rocco,
all right, thanks, Michael. Are you ready for me?
Oh, yeah. Take it away. For what? A relief, the lawyer's going to stop talking. See?
All right. I'm assuming everybody can hear me and see this screen. Is that correct? Okay.
Yeah, that's correct.
Yes.
All right. Well, I will give you welcome, and I'll give you a little background on me. I don't have as sophisticated a slide as Michael did with my undergrad degree, but my name is Rocco DiPietro. I currently work for Pennoni, an engineering firm headquartered in Philadelphia, although I work out of Northeast office in Scranton. I'm in the field for a little over 30 years. About a third of that worked in heavy manufacturing, the glass melting business, back when we used to make what was known as cathode ray tubes, or big TVs that weighed, 40 and 50 pounds, big chunks of glass. And then as technology advanced and flat screens became more predominant, that business subsided, and I moved into the consulting and engineering world, where I work with hundreds, if not thousands, of clients across a broad range of disciplines and business sectors, from K to 12 to government to manufacturing. So I'm a board certified safety professional, undergrad degree from Millersville, with MPH from Tulane. My portion of the slides today is not really to cover the basics, but to provide a little nuance and a little best practice. So as we start to delve into development of a heat illness prevention program. And I think the takeaway from the former slide deck from Michael is that we don't know what's going to happen. So it's kind of deferred then to employers to just make good business decisions that both support your business goals as well as protect the health and safety of employees. So with that latitude, that outside of a handful of states, Pennsylvania not being one of them, you're going to have some ability to customize and develop a program that works for your business. And I'm just trying to give you some anchors that as you start to develop this and adopt pieces from different programs, or you start Googling stuff, you know what some of the options are, what other organizations, consensus groups, states, and business associations have adopted. So my topics are kind of to cover that nuts and bolts piece, outside of things like, yes, you need to have a written program. Yes, you need to do training. I'm focusing in on some very particular areas to give you, again, some points of comparison as you start to develop your individual programs for your employees and your site. So I'm going to talk about triggers. When does the program get implemented? Do we wait for certain temperatures, times of year, geographically? What measurement tools? So when we have a trigger, what are we using to measure that trigger? So I'll talk a little about the current measurement tools that are out there. Also touch on indoor versus outdoor. I know most of the audience here is construction related, but that doesn't preclude you from working and being exposed to heat hazards inside of a building, which are treated a little bit differently and have some nuance to corrective actions inside. Of course, individual susceptibility is a challenge. That's one of the key areas where any rulemaking is going to run into individual susceptibility issues. This is not as black and white as, say, exposure to radon or exposure to PCBs, where we know at what levels things become toxic. Here, the same heat and the same conditions will affect people in dramatically different ways. So that's a challenge for employers. Climatization is the cornerstone of any of these programs. Michael mentioned it earlier. That is the key factor in anything that you're writing, and in any implementation is going to be this acclimatization factor, a physiological response. And then I'll touch on very briefly one or two slides on the emergency response requirement. So I am going to go through this quickly in a spirit of trying to get it done in about 20 or 25 minutes to allow for some questions and answers. And Beth has promised to keep me honest in terms of the time frame, so that when I get to the 10-minute left mark, I'll speed up if I need to. But in terms of, and at any point, you don't feel like you have to wait for a question. If there's something curious, you're bothering you, I can't see the chat bar unless I move my mouse. It kind of goes away. So I'm hoping if there are questions, you can put them in the chat and I can get to them at some point. Generally speaking, when we talk about triggers for your program, when is it going to be implemented? We look at three broad categories. I think everybody assumes the environmental factors, right? The temperature, the humidity, wind, those kind of environmental factors are the majority of triggers that we see implemented in individual programs as well as adopted by states, and I'll touch on those. However, some more sophisticated programs where maybe the risks are a lot higher or the stakes are much more advanced, we'll look at workplace conditions. I show an individual asbestos abatement. We do a fair amount of asbestos project design. So in a normal building on a normal temperature, folks may not have a problem, but their job is to contain those hazards. They specifically cover every surface with 6 mil impermeable poly, cover and shut off HVAC systems, and deliberately introduce copious amounts of moisture. So what may be a normal condition on a normal day for an asbestos abatement contractor can become a high hazard risk situation very quickly. Same thing for workload. We will see programs that have different triggers based on what it is that you're doing. The physiological response is a key component. So it's not just temperature. Walking across the parking lot in 95 degrees is a lot different than digging out a water main break by hand with a shovel in 95 degrees. So when we factor in what the workload is, that may also adjust triggers. So just a quick look. Michael mentioned the proposed standard. Chart comes from that proposed standard. One of the ways that OSHA has allowed employers to base their trigger is through the heat index, which is a combination of temperature and humidity. Very simple, easy to understand, very widely published data on a regular basis. So we look at kind of an initial, for those that are familiar with the industrial hygiene world, we would call this the action level at or equal to 80 degrees Fahrenheit. We would start to do implementation of whatever your program is. And then kind of the PEL level would be at heat index of equal to or greater than 90 degrees. And then we'll see a ratcheting up or an escalation of the response, whatever that response may be. I mentioned earlier that in addition to the federal ambiguity that Michael mentioned, some states have taken the prerogative to regulate this hazard since there isn't a federal regulation. And we do see that as a state plan, you have to be equal to or more stringent than the federal rules. So we have seen a handful of states that have state programs implement these rules. They vary widely in terms of what industries they apply to, what triggers they use, what protective actions they have. But I put a sampling of those up on the board. There is also a recently passed rule in Maryland that very well may affect our audience here in Pennsylvania, since it's a border state. But you can kind of get a look-see at some of the triggers Some are indoor, some are outdoor, some don't differentiate. There are separate rules in agriculture in some states like California than there are for general industry or construction. But generally speaking, they're temperature-based or heat index-based triggers. That's when your plan is going to kick in. In terms of monitoring, OSHA has also provided a term called the WBGT, wet bulb globe temperature. And I do have a few slides on what that is and how that's calculated. But that's a more refined, calculated value than just temperature. There are a number of variables such as radiant heat, evaporative loss from wind, shade, that all really can change the dynamic of the heat exposure. And heat index just doesn't allow for that. It's just looking at two variables, temperature and humidity, cannot account for the difference in temperature from shade to sun, or from a 20-mile-an-hour breeze to no breeze. So there are measurement tools that we'll talk about in the next section that do account for some of that differentiation. Speaking of measurement tools, there are categories of measurement tools that we would look at. Environmental monitoring, kind of the gold standard, if you will. It's what most people think of when we say we're going to measure whether or not there's a heat illness risk, WBGT, which I'll show you in a second. There are a variety of heat index calculators that are available commercially that do factor in temperature and humidity for your specific geography. NOAA and the National Weather Service has a heat risk tool. Nice portion of that is that it does allow forecasting. So not only can you measure instantaneously what is the heat risk today in Scranton, Pennsylvania, but what is it purported to be for the next 3 days? Is this a heat wave coming on so that we can ramp up our response? So the NOAA tool, the National Weather Service tool, does allow some forecasting. There are also mobile apps, two of which I'll talk about, as well as kind of the old school way we used to do this when we talk about the military, the fire service, as well as now incorporating advanced technologies, including wearables, individually measuring heat risk at the individual physiological level. That's very sophisticated. So let's touch on each of these so that folks have an understanding. When you hear WBGT, that is an acronym, as I said, for wet bulb globe temperature. It is a measurement device, is an instrument that calculates, and I've put the formula down there. This happens obviously electronically in the instrument, but it looks at three individual components of the environment. The wet bulb, which is now they've moved away from this, but this shows basically a saturated wick in the middle. So that is accounting for evaporative loss. If there's a wind, a breeze, a fan moving, we would see increased evaporative loss. So we look at the wet bulb temperature as for evaporative loss. Globe temperature captures, that's the black ball, the radiant heat. And again, we would see that dramatically different from sun to shade. Or in the indoor setting, if we were, I mentioned I was in the glass industry, we melted 40 or 50 ton of glass at a time. That would come out glowing orange, and the radiant heat would be incredible. So the globe temperature looks at radiation heat. And then the dry bulb temperature, what we normally attribute when you say what's the temperature outside, dry bulb temperature is that. So the factor of each of those kind of gets mushed together in a formula, 70% of this, 20% of that, 10% of this, and we get a calculated value that we can then take action on. So again, why we use it? Because it's a more accurate representation of how people react to heat, how it feels, not just temperature or humidity dependent. So again, this happens to be the ACGIH triggers. They are based on WBGT temperature, and they've separated them into 3 subcategories, recognizing that acclimatization is a key component into how individuals respond. So again, I won't work through each of the algorithms, but to mention that it is a WBGT trigger, which again, I would say is the gold standard in terms of that. But that instrument hanging out here is probably about I don't know, $3,000 or $4,000. You're not going to put one of those on every job site. You're not going to have 100 of them laying around because they're very expensive. Mobile apps are part of the new technology that we're really starting to see proliferate into the workforce. Everybody's got a phone somewhere or other. They're carrying around both NIOSH has a heat app, relatively limited. It is specific only for outdoor use, and it does grab your GPS coordinates, so it is geographically linked, where AIHA, the American Industrial Hygiene Association, also developed, subsequent to NIOSH, an improved version of that that allows employers to add some of those layers that we talked about that can dramatically affect somebody's response. PPE, working in a Tyvek suit or in coveralls versus regular work attire, cloud cover, sunlight, workload intensity. Is it light work, sitting at an office on my pounding rivets, installing scaffolding? They have dramatically different responses. So both of those apps, links are provided. You can do some research and download them. They are both free. The last of these measurement tools really looks at the individual. Physiologically, am I at risk during this time? Using that data, which looks at core body temperature, heart rate, respiratory rate, skin temperature, even colorimetric testing. I mentioned the fire service. We worked with fire services for a very long time. You may still see this in places where there is heavy work demand. There's a urine color chart that allows folks to kind of gauge their hydration level by the color of urine. And it's a simple but effective way to know whether or not I am adequately hydrated. My personal exposure based on those identifying factors. And again, physical workload also is something that we can calculate. There are tools. There's a compendium of physical activities. So if I know I'm working in a bakery, I know generally how much energy I'm expending. The more energy you're expending, the more heat you are generating, the more likely you are to have heat illness related effects. So again, there's a tremendous amount of science behind that physiological response. And as we see this with some of the new wearables, some pictures there of various sensors that can be placed on an individual. There are concerns. I'm sure Michael could comment, but you don't want your heart rate and blood pressure to be public knowledge to the entire organization. So you have to have some concern over protected health data. The accuracy is sometimes questionable. The device in the middle of that armband goes for about $1,000. Plus, you got to buy, subscriptions. So again, you outfit 5 or 6 people with that. You're looking at almost a $10,000 expenditure. So they can be fairly expensive if you decide to go that route. Spend a second just talking about the differences between indoor and outdoor exposure, knowing that in this audience, outdoor exposures, the predominant type of individuals and businesses that we're dealing with. So the heat sources tend to be a little different from my manufacturing days, where we had annealing ovens and furnaces to deal with from sunlight. When you're outside, the sun is the enemy. Airflow, we had to mechanically ventilate. That's typically not happening during new building construction. You don't see a lot of fans or portable air conditioning units employed in the construction industry. Humidity, again, difficult to dissipate if we're dealing inside of a building where we're generating moisture. And again, some of the control measures, pretty much all of the plans call for work, rest, shade. Water, rest, and shade. Those are kind of bread and butter. You've heard that, you've seen that 1,000 times. I'm really not going to focus in on that. But those are tried and true. I think they'll be a part of any standard that comes out, is some kind of work rest schedule, plenty of hydration, and then escaping the radiant heat through providing some shade, some cooling stations, maybe even some ventilation in those, so that those individuals have a spot to go that does give them relief. If we're going to be working outside, last thing we want you to do is take your 10-minute break, sit in your pickup truck while it's off, generating more heat. So again, some contrast between those. And again, in terms of the prevention strategy, this happens to be an annealing oven that has a nitrogen blanket on the outside of it to keep that heat in. That not only obviously makes the oven much more efficient and stable in terms of temperature control, but it protects workers that are immediately adjacent to that. So in terms of the preventative strategies, what we see in the construction industry, you have the ability to maybe start earlier in the day or work later in the day, maybe work nights to try to avoid the peak ambient temperatures or peak sunlight periods. That's obviously not the case if I'm indoor in a manufacturing environment working an 8 or 10-hour shift. Shade, acclimatization, and the buddy system, kind of the tried and true, going to be a part of any standard that gets adopted, if a standard gets adopted. On the inside, what we tend to see is work rotation. Maybe there's a particular area that's hot. We'll rotate people in and out every hour or every half day. We can do some shielding. We can do some ventilation that typically isn't afforded to those people that are working outside. Individual susceptibility, just kind of keep in mind, again, that not every individual is going to react the same way. Try to a one-size-fits-all program that accounts for all of the permutations of just those things that are on the screen. And that's probably not all of the individual factors, but age, obvious. When we see the deaths that unfortunately arise from a heat wave, if we have a multi-day heat wave in a major metropolitan city, Chicago, New York, unfortunately, it adversely affects the elderly. So we see the older people get, the less likely they are Obviously, the young really isn't a factor in an occupational setting, but your physical conditions, medications that you're on may impact. You're in a water pill. They have the ability to affect how the heat impacts you and your organs, weight, fitness level, hydration. All of this is very much individual, and that becomes part of the challenge that regulators are having, and why it's 2025. We know that heat can have an adverse impact on health, but we don't have a standard because a lot of it has to do with items that are on this sheet that present a challenge to you as the employer, particularly trying to get a procedure that's implementable or a protocol with all of this that may factor in. I mentioned I'm going to close with the last couple of things. Acclimatization is the most critical piece of anything that you do in terms of what your triggers are, what your protocols are. Recognizing acclimatization as the most important piece, I think, is absolutely critical. And there is standards that drive these. Most of these came from the military, but they have been adopted. They present challenges. I'm well aware of that. I've worked with a bakery client in California that does have a heat standard that uses a lot of temp workers, and they don't know who's going to show up from day to day. They don't always get the same workforce. That presents a huge challenge when I've spent 3 days acclimatizing, worker A, and then they are not there, and worker B comes in, and they haven't been acclimatized. So yeah, it seems pretty simple. If you start a construction individual on day one, you're going to ease them into this. But what happens when the workforce changes over time? What happens when people leave? The good news is that you will acclimatize in 1 or 2 days after being gone for a few days. If you're gone for 2 weeks, I recently went to Scotland for 2 weeks. Fortunately, I didn't have to reacclimatize because it was just as hot there as it was here. Wasn't supposed to be that way. But if I was in Highlands for 2 weeks, exposed to 40 or 50 degree temperatures, and then came back to Northeast PA, experiencing a day like today, I really wouldn't be very productive, or I expect to be productive on first couple of days. Important point here is the duration is usually what we try to do is shorten the time. It's not a matter of just stay out and work lighter. It's a matter of the most effective acclimatization programs shorten that duration. So rather than 8 hours in the heat, you're going to start with 2, 4, 6. Not necessarily important what you're doing during that time in terms of developing the acclimatization program. Some of the states do have these built in, recognizing that it is key. So if you are in California or Maryland, you will have a very prescriptive regimen. Bring somebody into that work. Michael mentioned, heat in Alaska or Minnesota versus Tucson. We would think the heat injuries would occur in, those places that are the hottest, Tucson, Florida, Louisiana, when in reality, that is not the case. Simply because of acclimatization, it gets to 90 degrees in Minnesota. Folks are not used to it. It's kind of, think of it as like when you get an inch of snow in Atlanta and the whole city shuts down. You get 90 plus degree temperatures in Portland, Maine. Things don't happen the way they were normally designed to work. Here's some key takeaways. We know that the vast majority of people that have succumbed to a fatality, heat-related fatality, do so in the first few days of work. That's a statistical fact, and again, speaks to being sensitive to acclimatizing your employees and recognizing that So again, I think I touched on most of the other pieces of this. I'm going to close the last couple slides with emergency response components. In addition to your written program, which details a lot of the items I just said, all of the programs are going to have this emergency response phase, which again, if you're in a manufacturing environment, probably isn't a huge deal. You're used to having first aid, a medical director, protocols, a phone, you know where everybody is in the plant, you got a floor plan. However, if you're clearing trees on the side of a mountain, or you're putting in a well pad in the middle of the woods, things can be much more challenging to be able to get medical services to you in a time frame that's going to impact your life. So core elements that we see in all of these as a best practice is that it is site specific. It's not just going to be something you can grab off the internet and utilize it in every one of your plans. People have to be trained to recognize the signs and symptoms. It's not just enough to say, when you're hot, slow down. 911 should be called immediately when there's a suspicion of heat. Even though you may be able to cool somebody off, the damage may be past the point of return, and you may not be able to reverse that damage that's being done. Should somebody experience heat-related signs and symptoms, cooling the body, getting them to shade, pretty extreme cooling methods absolutely would work. I'm not a doctor, but there's a number of cooling vests, wet blankets, towels, fans, air conditioners that be able to cool the body down and start to reverse that rapidly increasing temperature. Things you don't want to do is just send somebody home, or you're feeling lightheaded and dizzy, take the rest of the day off. Now we put them in a car, and we don't know what's going to happen to them. So having reliable communication, again, may be an issue. If you're in a remote location, you can't call 911. And even if you were to call 911, how do you direct them to where you are? How do you direct them to pick up that individual on the side of a mountain or in the middle of a field that may not have improved roadway? Last slide, again, kind of the best practices that have been stripped from some of the programs is that emergency response procedure obviously should be on site. No one should be sent home or left alone if they have signs and symptoms. They should be immediately paired up with somebody to monitor them. Again, I mentioned transportation. Calling 911 is a good first step, but being able to direct them specifically to where you are and to be able to transport that individual may be a challenge given the construction nature of the assignment. Assigned staff, designate someone to administer your program while they're on that site. It is not unheard of for states, California specifically, to have an individual identified for that role and to have the ability for anybody to call 911. Some people, they say, you can't call 911, you got to go through the supervisor. In the case of a heat emergency, you need to be able to call 911. Language, obviously you got to be able to communicate. And then lastly, that we don't see a lot of, and I've dealt with a number of clients, I very rarely see anybody practice this. We may practice fire drills, we may practice active shooters, but I'm not aware of any of my clients that are actually practicing the response to a heat illness emergency, or even tabletopping it. We have, the ability to do time trials. How quickly would it take EMS to get here? How quickly would it take us to get somebody to the road so that they can be transported? Unless you do this on a regular basis and you practice, you're not going to be as effective as you can right out of the box. So apologize, I did go a few minutes longer. There's my contact information. Should anybody want to reach out to me, or if I can be of any assistance in answering questions. Otherwise, I'll open it up to questions. And Beth, turn it back over to you.
Well, thank you. I do have a question. So I noticed that if you're drinking a quart of water an hour, after a couple hours, do you ever have any issues with electrolytes where you need to supply employees with electrolytes? Because too much water dilutes your electrolytes, and I don't know if that's an issue or not in the field.
It certainly can be, but it is not normally an issue. You have to have a pretty significant sweat load to be able to drop your electrolytes. So, most entities will just prescribe water. I mean, if you're an Olympic athlete or something along those lines, possibly, supplementing with, a Gatorade type product or something with electrolytes. But the vast majority of us are not going to deplete that. What is more important is that, and I didn't include a whole section on hydration here, you can't wait till the day of to start hydrating. If you know you're going to be working in the heat, you have to start the day before in order for that water to get into your cells. So what we see is that rapid onset of dehydration starts simply because, they get out in the morning, they have a cup of coffee, which is bad. They had alcohol the night before, which is bad. And now they start drinking water at 9 or 10 in the morning. It's too late at that point. Your body won't be able to absorb it. But we're not necessarily electrolytes for the majority of people. It's not going to hurt you, but it's just not necessary.
Good to know. Mm-hmm. I really like the idea of I never thought of that, having a training session so people know what to look for in heat stroke and heat exhaustion, and then also having that ability to know how fast you can get help for that person. That's something I learned, a key takeaway for me.
And I think Michael would confirm this training for both staff and for supervisory personnel are pretty much a part of all of the programs that are being proposed, because some of this is, recognition and identification of the hazard is, paramount. So they usually always have that element to them.
Rocco, instead, if I may, the point about training, I can't emphasize that enough. So many of the defenses an employer will have to both an employee injury or an OSHA citation pertain to the amount of training that each of the employees has had and the extent to which that training is documented. And so I always encourage my clients not only to document the formal training, if you have a third party come in, et cetera, keep the curriculum, have a sign-in sheet, et cetera, but also the informal training. If you take a time out in the middle of a workday, say, wait a second, hey, so-and-so looks, they're not even sweating anymore. That's a problem. Get this person water. And there's a discussion on site, then that should be documented because that is to the employer's benefit as to their degree of attention to safety. And if you don't believe me, I can't tell you how many times an inspector comes on site and boy, they love to ask the employees, well, have you been trained and what kind of training and when and how often, et cetera. And if there are no good answers, then I'm doing this. So,
and what we see, Michael, is a lot of times when we know that heat wave is coming, there'll be a daily toolbox talk or whatever we want to call it, tailgate, tailboard, that never gets documented. But, supervisor is going to start the day saying, listen, we know it's going to be hot. Please make sure you're hydrated. If you need to cool down, I got the trailer over here or whatever, that probably goes on, but never gets documented.
I always say, like, people talk about tech in the workplace or tech in construction. And I always wish that supers would have just like an iPad in one of those, OtterBox cases. And they could just have a bunch of drop-down menus and be like, toolbox talk, safety, heat hazard. These guys are there. Boom, 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 boom. Check out, and then goes right to a database. No clipboards, no pencils, no nothing. Right in the company system, and then it's there forever. And I love stuff like that, and I love just pushing a big pile of paper across the desk at OSHA saying, "I think we did take care of safety findings." But I can dream. A man can dream, right?
Yes.
Any other questions? Comments?
None for me. I was going to have some questions about emergency response, so thanks for including that at the end there.
Good. Thank you very much.
All right. Well, if there's no other questions, I just want to, on behalf of the KCA Safety Committee, I appreciate everyone being here and for our speakers to educate us on this important topic, especially now that it's summer. So thanks, everyone. And that's the wrap.
Thank you.
Okay.
All right.
Again.
Thank you.